rise. The Court of Appeals Division 1 is now in session.
Please be seated. Welcome. We are here today for oral argument in Unemployed Workers v. Ducey, 1 CACV 220054. Each side has 20 minutes for your argument. You can reserve time for rebuttal. Just if you can keep that yourself, we would appreciate it. Introduce your client before you begin. We've read the briefs, conferenced the case, and we're familiar with the arguments. And with that, let's begin.
Good morning, Your Honors. May it please the Court. Josh Bendor of Osborne Maladon for the plaintiffs' appellants, and with me is my colleague, Josh Messer. I will endeavor to reserve about 8 minutes for rebuttal. For a period of time during the pandemic, the federal government increased regular unemployment compensation benefits by $300. The statute by which it did so, which is the federal statute at issue in this case, did not purport to create a new program. Rather, it simply increased the benefits available under the normal unemployment compensation program created pursuant to the Social Security Act. Critically, there is no new eligibility test for these increased benefits. Instead, a person gets the increase if he or she is otherwise entitled to regular unemployment compensation. The statute defines the sum total of these benefits, the standard benefit plus the $300 increase, as regular compensation. These benefits can even be provided in the same check. The statute provides that a state shall either provide the increase, quote, at the same time and in the same manner as any regular compensation, or by a separate payment on the same weekly basis.
So, counsel, let's turn to the statute, the Arizona statute 23645. So, what is? I think we first have to define the advantage. It's a plural advantages, but here, what is the advantage?
The advantage that is at issue in this case is the $300 or previously $600 increase in unemployment benefits for eligible citizens of Arizona. And those are provided, I think this is where Your Honor may be going, by the joint operation of 15 U.S.C. 9023, which is in the CARES Act, and the provisions of the Social Security Act related to unemployment compensation.
Okay, well, we'll take this one step at a time. So the advantage we're talking about is pandemic unemployment benefits.
Yes, and depending on how, there are other advantages that are related to how those advantages come into being, right? So there are the Social Security system, or rather the unemployment compensation system set up by the Social Security Act that the pandemic benefits then build upon, right, because they're the same program. But the benefits, the advantages we're suing over are, as you stated.
Okay. So let's talk about two things. We have the advantage. We've defined that. What funded that advantage? How do we get the cash or the federal government to pay those benefits?
Congress appropriated those funds.
In
the CARES Act.
In the CARES Act. And they were created or first recognized by what act? Was it the Social Security Act, the CARES Act?
Well, the increase in benefits is provided for in the CARES Act.
All right, I think we can make it even easier. The day before the CARES Act was enacted, was there any right to pandemic unemployment benefits?
Of course not.
Okay. So if we have the CARES Act that both creates and funds the advantage, how are pandemic unemployment benefits available under, I think those are the two words, the Social Security Act, or what's the other acronym? EUCA.
The reason is that those benefits as provided for in the CARES Act would not work without the existence of the unemployment compensation provisions of the Social Security Act. They only exist by the joint operation of two sets of statutes. As a practical matter, if Congress had just passed the CARES Act and there was no pre-existing unemployment compensation system, this statutory text that we're interpreting, the federal statute, would have been meaningless. There would have been no regular compensation that would have been increased. There would have been no weekly benefit checks to add to. And that's shown by the title of the statute. 15 U.S.C. 9023 is entitled Emergency Increase in Unemployment Compensation Benefits. It's not a new program. It's an increase in the existing program. So if Congress passes an enactment that says we're going to increase unemployment compensation benefits by $10 a week, or in this case by $300 a week, those benefits, I think the way they're actually made available is through the operation of both of those statutes, the way statutes often work in combination with each other.
So I didn't see either party define the words available under, which would seem to, they're used a lot, but how would you define available under?
I think we can think of that as because of. And an advantage can be available because of one statute, or in this case, more than one statute. Those statutes working together, which is, I think, what we have here.
So the available under, and you're defining it as because of.
I think that's one way to interpret the term. Your Honor is asking a good question, and none of the cases that have interpreted the similar statutes in other states have really defined that. I think because of would be one very reasonable interpretation. Could there be other reasonable interpretations? As I stand here today, I'm giving you the one that I think makes sense, but I'm not going to say, there can't be some other one.
Well, Indiana had a different verb. What was the verb?
I believe the Indiana statute, if I'm remembering that case correctly,
Dispense?
used conferred by.
Conferred by. Okay. So conferred by, that's Indiana, and here we have available under. And your argument is any statute on the books that is necessary or included as part of the system to deliver the benefits is a statute that these benefits are made available under.
Yes, and look, perhaps there would be some statute that is so far attenuated from the benefits that we would say, that's not enough to come within the meaning of ARS 23-645. I don't think that's what we have.
The other thing I didn't see a lot of is, can you tell me about this statute? The legislative history. Why is it on the books? Why did the legislature pass this 25-645? Sorry. Did you find anything on that?
I spent some time looking at that, and it provided fewer answers than I was hoping for. The origin of this statute appears to have come from a publication made by the Department of Labor in the 1970s. This is not in the record. We found this in preparing for argument. Frankly, I didn't think it shed enough light to warrant a notice of supplemental authority, because there's this publication by the Department of Labor that has some model unemployment statutes, including similar to this one, the one we have in other states, and it had some commentary that, frankly, I did not think really shed much light on the meaning of the statute. I think that the purpose is, as we tried to explain in our briefs, that the unemployment compensation system created under the Great Depression is a cooperative federalism system, right? And it requires the federal government set certain standards, provide certain grants, provide certain tax benefits, certain certification and technical assistance, and then the states enact certain laws to put that into effect. So they have to work together, and these agencies do, in fact, work together. And so this is part of that working together. I don't know if the legislative history sheds a lot more light on it than that, Your Honor.
Does it matter at all? Well, first let me ask you, the Social Security Act and the EUCA, those are mandatory. programs in which the state must participate, or is that the case? Like here we have a permissive, it's sort of peppered. It's in the CARES Act. This is permissive. You can leave on 30 days. It's in the agreement that the state signed. So qualitatively, I guess the first question would be, are those other acts, like could Arizona just say, we're not doing Social Security?
My understanding is that Arizona is not required to participate in Social Security. There might be an anti-commandeering problem if it were. Rather, what the federal government does, as it does with many programs, is it holds out carrots and sticks. It provides the availability of funding to induce states to participate, and enough states find that worthwhile that they do.
Very good point. Very good point. But in this case, are there carrots and sticks that would make Arizona, other than getting benefits for its residents, unemployed residents, that the federal government deployed or employed?
In this case, the carrot was that the federal government entirely fully funds the benefits we're talking about, including the costs of administration. So there is to be no financial cost to the states at all. Good
point. So maybe I don't mean carrot, I mean stick. The federal government often acts through sort of punitive measures. You participate in this. It's voluntary, but economic ruin is on the other end of the spectrum. Is there anything like that?
There's nothing in the statute. There's nothing to my knowledge that they say you lose this other funding if you don't participate. And we're not alleging that Arizona violated federal law by terminating its participation. Our claim is simply under the state statute, ARS 23645.
So, counsel, you would agree then that the 90% whatever tax credit that the state of Arizona gets by participating in the Social Security system, that cooperative system that you had described before, that isn't endangered by a refusal to accept CARES Act funds?
Well,
at least from the federal level?
Yeah, well, so let me try to give my best and nuanced answer to that. Under the Federal Unemployment Tax Act, the certification requires compliance with the Extended Unemployment Compensation Act, the EUCA. So if the court were to agree with us that the benefits at issue in this case are EUCA benefits, which is one of our two arguments, then, and if the federal government decided to act on that, then the state certification would be in danger, but that would be discretionary on the federal government's part. And the court could find for us, without reaching the EUCA issue, and simply by holding, as I tried to outline in my opening, that these funds are provided for under the unemployment compensation provisions of the Social Security Act in combination with the CARES Act.
But the inside of the CARES Act as an act itself, there isn't a provision in there that says failure by the states to accept the benefits under the CARES Act will result in an EUCA penalty.
Correct.
There's nothing in there like that.
Okay,
so then your argument presupposes that those CARES Act benefits and EUCA benefits would be the same. That's what would trigger any kind of stick, as has been characterized here.
Right, and we're not appealing to the federal government to impose a stick. We're just seeking an order from the courts of this state requiring the state to comply with state law in providing for these benefits. But yes, I am agreeing with Your Honor's point.
Right, because it's available under, I guess, the EUCA and the SSA.
Correct.
Okay, so is the delivery system or the use of the delivery system provided for under the SSA, is that necessarily transmute something that comes from another act, funds that come from another act into part of that system itself?
Not necessarily, Your Honor. I think it's the other factors primarily that I tried to outline. This is an increase in benefits under an existing program. There's no new eligibility requirements for an individual Arizonan who would try to get these benefits. It goes in the same check or at the same time. It's really just piggybacking on an existing check that someone gets.
Does that not? I have the image of of the difference between the circulatory system and the substance that's circulated inside of the circulatory system. So is it not conflating blood and veins to be talking about those things in the same breath?
Well, I don't think so. I smiled because I was thinking about it, an analog to the circulatory system this morning, in the sense of when something can be conferred by or available under more than one thing. So the oxygen that flows to my blood cells is there not just because my heart pumps it, but also because my lungs breathe it, right? It's there as a result of both of those things. Similarly, these benefits are or were provided to Arizonans as a result of the unemployment provisions of the Social Security Act and as a result of this provision of the CARES Act. You can't just say one or the other. It only works through the joint operation of the two. And similarly, they are defined in the statute as benefits under the EUCA. I see I have 5 minutes later.
Let me ask you. So let's assume people act and governments act for reasons, okay? And so this is happening in the backdrop of a pandemic in which benefits and relief must be distributed and distributed fast if it's going to make any difference. If we accept your argument, then doesn't the federal government each time have to sort of, out of whole cloth, recreate accounts or chutes, constructed highways that already lead to these places? They can't sort of leverage or take advantage of sunk costs. So I'm an economist. So that would be inefficient, or they can't lean on existing well-worn definitions, because then it's all available under these older statutes. What do you think of that?
I appreciate Your Honor's concern. I don't think a ruling would have to have that consequence, a ruling in our favor. And let me give an example of one of the other unemployment compensation provisions in the CARES Act. And that's in 15 U.S.C. 9021, and it's called the Pandemic Unemployment Assistance Program. That's, it's just a couple statutory sections behind the one we're talking about today. And that one is expressly for individuals who do not qualify for regular unemployment compensation or extended benefits, and who are out of work for some reason related to COVID. So I think, the court could distinguish, could argument be made that that would be included too? Sure. But the court could also distinguish those two and say, look, when you have something that's just adding $300 a week, as we have in our case, to an existing benefit check using the exact same eligibility rules, that is available under the existing system. By contrast, when you have a statute that's for people who wouldn't be eligible under the existing system, that's different. I think you could draw that line, or perhaps there are other lines that the court could draw.
Okay.
If there are no other questions at this time, I'd like to save the balance of my time.
Okay.
Thank you.
May it please the court, Timothy Berg of Fenimore Craig on behalf of Appalese Governor Ducey and Director Weishart. The CARES Act, which established the, I'm going to call it FPUC, it's FPUC, everybody crazy with acronyms, and I apologize in advance for using them. That created the program expressly provides that Arizona may enter into an FPUC agreement with the federal government if it wishes to do so, and may terminate such an agreement upon notice to the Secretary of Labor.
But that would be, that's sort of irrelevant, isn't it? If Section 25, whatever, 23, I'll just call it this statute. If the statute embraces the CARES Act, what?
Yes, Your Honor, but I think one reason not to read the statute that way is to recognize that the federal government created an optional program. It created it 43 years after this Arizona statute was enacted. And what plaintiffs are trying to do is take an optional federal program and turn it into a mandatory program by reaching out to an Arizona statute that was passed without any idea there'd be COVID or a pandemic or an FPUC program or a CARES Act or any of those things. And the reason that they're not here suing under federal law is that, or in district court or Ninth Circuit suing under federal law, is that the statute was intended to be optional. It was intended to let the state of Arizona decide whether it wanted to participate and how long it wanted to participate. And that's exactly what my clients did.
Well,
They
apparently
entered in-
Social Security is also optional.
Well, Your Honor, again, I think it's a different structure, it's a different setup. This one was clearly intended to be optional. If you look, you have to enter into an agreement with the Department of Labor to get FPUC benefits along with the other benefits. The agreement expressly provides it can be canceled on 30 days' notice. That's not how the Social Security system works. This is a much more temporary, informal, emergency system. It is something separate and apart from the Social Security system. As a
How do you,
consequence.
Mr. Brooke, how do you define available under?
Somehow I knew you were going to ask me that, Your Honor, so I came up with that answer. I think available under for these purposes means brought into existence by and funded by. So in this case, the FPUC benefits were brought into existence by and funded by the CARES Act. And so they are available under the CARES Act, not under some statutes that were passed, my math's going to be horrible, but I think in the case of Social Security Act, some 70, 80 years before the CARES Act. To me, to say available under means that because the federal government decided in the interest of getting these benefits distributed quickly to use an existing mechanism to distribute those funds, converts them into funds that are available under the act that creates that mechanism is just wrong. Available here means where does the money come from and how is it funded? And the answer is it's funded from the federal government through the CARES Act. The CARES Act creates these benefits.
So it's almost like it's almost like your colleagues are arguing that the Social Security Act and the EUCA are some sort of enabling statute, and that everything that comes in its wake on the issue of unemployment compensation falls under that. What do you think of that?
I think that's wrong both as a matter of federal law and as a matter of the way 23645 reads. If the let's take 23645 first, I'll do it in reverse order. If the legislature had intended to say the state has to take advantage of any benefit that ever becomes available under a federal unemployment program, it could have said that. Instead, it said you have to go get benefits under these specific acts and programs. You have to read the statute as saying what it says. And so I would suggest to you that that isn't what the legislature meant. Second, if Congress had intended CARES Act aid to be part of the Social Security Act or part of the FUCA Act, they could have amended those two acts, or one of those two acts, to provide the benefits. And in fact, as Judge Cooper pointed out in her opinion, some parts of the COVID relief package in its broadest sense did result in specific amendments to the Social Security Act. And so had Congress intended to make this an additional Social Security benefit, they clearly could have done so. And again, I think the court has to take Congress at its word that this is a benefit created through the CARES Act. That's why they did it. And you have to take the Arizona legislature at its word that the benefits that the state's obligated to get are those in the statutes listed in 23645.
What about that shared, I think it's, unless I wrote it down, extended compensation definition? What's the significance of that?
Really none, because the extended compensation definition in the federal act doesn't include FPUC program. So it doesn't change anything about what's here. If you look at, I think it's 15 U.S.C. 921, 9021, I'm sorry, and 9023, what they do is they define certain benefits you need to be getting in order to be eligible for FPUC funds. And they define those as employment benefits. But they don't ever define the FPUC funds as employment benefits, and they don't define it as anything under the Social Security Act or the EUCA Act.
So it's just borrowing a definition?
Borrowing definition, as Judge Cooper pointed out, what Congress did when it passed the CARES Act was it borrowed some definitions from the EUCA Act. It borrowed the Social Security payment system as a way of making payments. But none of those transmute. I mean, in a sense, I feel like we're all alchemists and we're trying to transmute lead into gold. Well, I don't think you can transmute CARES Act funds into SSA funds or EUCA funds simply because it'd be like saying if you put gold and lead in the same pot, the lead becomes gold because I put it in the pot where the gold was. And that clearly isn't correct.
Counsel, isn't that quite a bit more of a finer point, though? I mean, you would agree with me that the CARES Act, what it is intended to do is supplement unemployment benefits, right? That's its purpose.
What the CARES Act was intended to do is give the states the opportunity to take advantage of additional federal funding to provide additional benefits. Yes, Your Honor.
But it's...
Yeah,
that's just a long way of saying that CARES Act funding is to increase the potential for unemployment benefits, or the benefits that states can give as unemployment compensation.
It creates an additional unemployment benefit under the CARES Act that the state can give in addition to its existing unemployment benefits. Yes, Your Honor. And I'm saying that deliberately because I think I'm saying something a little different than you're saying. I want to be sure I'm answering your question.
Well, and I think I understand what you're saying, but the whole point here is, okay, so going back to, you heard my analogy, right?
Yeah.
So it's not a matter of saying, hey, look, this is lead over here and this is gold over here. It's really a matter of saying that Arizona, the state of Arizona has said, hey, if it's blood coming out of these veins, then that's what it is. And then CARES Act maybe has plasma. So it's the question is plasma blood?
Actually, no. The question isn't is plasma blood. The question is plasma part of the veins and arteries that you're using to pump the blood. Okay. Your Honor used the analogy that the Social Security Act in this case is the vein, and that the funding is the blood. Well, if you want to keep that analogy further, well, all the CARES Act does is it doesn't become part of, let me try that again. The veins and the arteries are provided by the Social Security Act. The blood is provided by the CARES Act, whether it's in the form of plasma or it's in the form of funding. And the blood doesn't get turned into veins or arteries simply by the fact that you use the veins or arteries to deliver the blood, whether it's your original blood or your transfusion. It is a different system. The fact that the federal government chose to use the Social Security Act mechanisms to deliver this, don't convert it into a Social Security benefit. If the federal government had intended to do that, it would have amended the Social Security Act to increase the amount of the benefit. Or it would say or it would say in the CARES Act, we're increasing the Social Security benefit in this amount, and it doesn't do that. It creates a separate temporary benefit that actually went out of existence once and came back into existence again, but it's a separate benefit created and funded by the CARES Act and available under, I think, the fairest reading and most logical reading and frankly most true to the intent of the legislature when it enacted it, is they were looking at federal money that was available under certain statutes, money that was created by or appropriated by and funded by those particular statutes. And that's what the legislature meant. It didn't mean something that no one had thought of that came out later, that comes out under a different statute and happens to use definitions from one federal act and a delivery system from another.
So let's say, okay, I think we've all agreed that we have a benefit created by the CARES Act, funded by the CARES Act. I was trying to think of a metaphor. I came up with an irrigation system, okay? Because we're talking about not one body with veins. We're talking about distributing billions of dollars to millions of people, okay? And so I guess the question would be, yes, it was created and funded here, but once it was funneled through that irrigation system, which might not be surprising given the emergent circumstances, did that transform the advantage here, these benefits, into Social Security or EUCA?
And I think the answer has to be no, Your Honor. If you look at the CARES Act, again, had Congress wanted in the CARES Act to say, what we're doing is increasing Social Security benefits or increasing EUCA benefits by a certain amount, either forever or for a temporary period of time, or the Congress could have done that. And again, it did. As Judge Cooper pointed out, certain administrative expenses of running this program, it actually amended the Social Security Act to deal with. What Congress did instead is said, we're creating a new benefit that we're going to distribute through the Social Security system because we're sitting here in the middle of an emergency and we don't have time to create a new distribution system. But had Congress intended to simply amend the Social Security, to make these Social Security Act funds or EUCA funds, the easiest thing in the world would have been for Congress to amend those two statutes and say, we're providing additional SSA money or additional EUCA money. It did not do that. We argue that, in fact, the state of Arizona couldn't have reached out and gotten those funds even if it had wanted to in 23-645. But I think the fairest reading of 23-645 is it was never intended to do that. What it was intended to do was get federal funding and distribute it to citizens of Arizona under certain programs that existed when the statute was adopted and that are called out in the statute by name or site, depending on how you want to look at how one names statutes.
Okay. Yeah, I was going to say, how else could they have written the statute back? The Arizona legislature, if they wanted it to be forward-looking and to capture, I guess they could have added some language saying, and any programs that
They could have either not cited anything and just generally said any benefit available under any federal any federal Unemployment Benefit Act, or they could have said and any other federal Unemployment Benefit Act. Either of those would be, if the statute said that, then this would be a different case. But that isn't what the statute says. The statute basically lists, and again, it calls them out by name, for particular acts or provisions that the state's supposed to go out and get funding under. And the principle, all sorts of statutory principles, but obviously, had the legislature wanted to write that more broadly, it certainly could have.
Counselor, are you saying that it's not possible to interpret this statute as saying that the delivery mechanism itself is not what qualifies the benefit or directs the governor to accept that benefit?
What I'm saying,
Your
Honor,
it says all advance, so the governor shall take such actions as may be necessary to secure to the state and its citizens all advantages available under the provisions of the Social Security Act. Is that not the ability in Judge Weinsweig's analogy to say, there's the irrigation ditch, everything that comes out of this irrigation ditch, you need to go collect?
I don't think, again, I think it takes it back to where Judge Weinsweig started us. What does available under mean? What's the fairest reading? I mean, Mr. Bender admitted that you can read available under a number of ways. It's probably true, but I think the fairest reading of available under in this context, the one that's truest to the intent of the legislature, is benefits that were created by and funded by these acts that we want you to go out today and make sure Arizona citizens are getting. That's what the legislature did in 23-645, Your Honor. And of course, we make the argument that even had the legislature wanted to do something broader, it's limited in its ability to adopt future changes in federal law. I don't know that the court needs to get to that point, although it shouldn't lose track of it, because if you apply Occam's razor here, the simplest answer to this case is to read 23-645, I think the way the legislature intended it to, which is to apply only to these particular programs and only to benefits that were created by and funded by those particular programs. Not that the accident that Congress chose to distribute these funds through the SSA, rather than creating a separate distribution program, doesn't change the nature of the funds. They're still CARES Act funds. They're not SSA funds. Take Judge Weinsweig's example. If I pump groundwater and put it into an irrigation ditch and deliver it down, the fact that it went into the ditch doesn't change it from groundwater to surface water. It's still groundwater. It's all water being delivered by the ditch, but there's a difference in this state at least between groundwater and surface water. And that wouldn't change the character. Here you have CARES Act money that's coming into the Social Security Administration system. It's being distributed by that system, and it's still CARES Act FPUC funds.
There could be a crack in the irrigation system, and theoretically, if it's time-tested, I mean, the government's so great at creating new administrative agencies or processes that they could have done a better job. I mean, I guess that's the argument. They could have done an equivalent job without using the existing irrigation system.
Yeah.
And there's meaning or significance to the fact that they not only used it, but had to use it or felt they needed to use it.
Maybe, Your Honor, we wouldn't be here if one of two things had happened. One, Congress had said, we're increasing benefits under the Social Security Act by X amount. Or two, Congress had created its own distribution system under the CARES Act to distribute the CARES funds. I mean, this case would be easier on one side or the other if one of those two things had happened. Unfortunately, that's not what happened. And I think you're right as to the reason. Congress was concerned about how long it would take to create another distribution system. And so it said, we have this money, it's new money, it's CARES Act money, it's optional money, it's going to only go on for a certain period of time, and we're going to try to get it out as quickly as we can using the existing federal system. I can't remember which of the cases we cited to you, and I apologize for this, but it's one of the other state cases makes the point that the federal government did this in other ways in the CARES Act. It distributed PPP, I think it's PPPL money, through the Small Business Administration. It didn't change the nature of the PPPL money. You still had a PPL loan, and you either had to qualify for it or pay it back, depending on whether you qualified for it or not. But again, the federal government used an existing distribution system because they understood that they were dealing with something that needed to be dealt with immediately. But doing that doesn't change the nature of the aid being given. If the court has no other questions, I'll conclude there. Thank you very much, Your Honors.
I want to pick up with where Mr. Berg was talking at the end. And he said this case would be different if Congress had said it was increasing the amount of funding provided in the Social Security Act by a given amount. And that's basically what this statute does. It just doesn't use those magic words. So the title is Emergency Increase in Unemployment Compensation Benefits. If you look at 9023B, it increases the amount of regular compensation. The total is then defined as regular compensation. It's to individuals who would otherwise be entitled to regular unemployment compensation under existing law. And so this is an increase in the existing unemployment compensation benefits. They just didn't say the magic words that apparently is the test that the defendants want. But there's no reason to read ARS 23645 to require those magic words. You know, it's going to the oxygen and blood and veins analogy. This is not just distributing blood through veins and arteries. This is increasing the amount of oxygen in every blood cell, like it's increasing the amount of unemployment benefits in any particular check that a person would be getting.
What about the argument that the analogy was, hey, this is groundwater, so you have a right to some surface water, and Arizona says you have the right to surface water, but they say nothing about groundwater. Okay, so are you arguing that because this CARES Act money is water, that it's no longer groundwater? It's because it entered the canal? Is that the argument?
I'm not sure, but our argument is that because this is simply an increase in the existing benefit, then it only exists because of the existing benefit plus this new legislation. And ARS 23645 doesn't refer only to advantages that are listed in the Social Security Act. That's the way that the defendants want to read the statute. But those are not the words in the statute. It says available under, which is broader than listed in. And it would include an increase in benefits, even if it's because two statutes have to work together, or even if three statutes have to work together. You have one like the CARES Act, and then you have a separate appropriation bill. Why can't that all of the benefits that result from 3 different statutes working together be advantages available under. I think that's the most natural way to read ARS 23-645. I see my time has elapsed. If there are no further questions, we ask the court to reverse. Thank you.
I don't have any. Well, let me first thank you both for your excellent, helpful arguments. It makes it much easier on us, and we appreciate it. With that, we'll take this under advisement and have a decision out in due course. We are adjourned.